I have to figure out. This is new. All right. God, these lights are blazing.
Yeah, this is real.
It's like unbelievable.
Should have our makeup people come.
Ready to go?
I'm ready when you are, Ashley. But I think we're
2 minutes.
Let's go.
Give me 1 second. Well, good afternoon, everyone, and welcome to the Carnegie Endowment for International Peace. I'm Ashley Tellis, a senior fellow at the Endowment, and it's a real pleasure to welcome you and, of course, everyone who's in the virtual audience, wherever you are. Welcome to this discussion of China's law of the sea. You can see the photograph of the cover of this book, which Isaac Kardon has recently authored. And we want to have a discussion today about themes that emerge from the book, because the subject's importance, at least to my mind, is simply self-evident. Besides disputes of sovereignty, which obviously have real consequences for international peace and order, the question of contesting maritime claims is probably only second as triggers to future conflicts in the Indo-Pacific. China is a large country. It has competitions with many of its neighbors over maritime equities, and therefore trying to understand what is it that has propelled China to take the positions it does on issues in the maritime space is really something that we ought to pay some attention to. And that's really why this afternoon's discussion is so germane. We have two individuals on the stage before us, both of whom happen to be great colleagues. I have to say that in the interests of truth in advertising. But beyond just being great colleagues, are also formidable scholars. Let me start with Isaac Kardon, who has recently joined us at Carnegie as a senior fellow in the Asia program, focusing on China studies. He was formerly at the US Naval War College in Newport, and was part of the China Maritime Studies Institute, where he focused on Chinese maritime policy, China's approach to ports and its physical infrastructure, and so on and so forth. And this is a book that originally was a dissertation that has now been brought up to date as part of the publication process, as part of his publication process. To Isaac's right is Fiona Cunningham, who is an assistant professor of political science at the University of Pennsylvania, where she spent a bit of time focusing on issues pertaining to technology and conflict, but has had actually a long history of interest in issues relating to nuclear weapons, to space, cyber and missile technologies. In fact, I first knew Fiona from her work on the Chinese nuclear program, which I hope she still continues to pursue. Beyond just being a professor at UPenn, she's also part of the Carnegie family, because she spent time here at this institution as a fellow years before she went into academia. So very warm welcome to you, Isaac, and to Fiona, and I'm really looking forward to this conversation. What we're going to do this afternoon is I'm going to invite Isaac to speak for about 10 minutes to lay out the themes of the book, because I won't presume that you've read it. And then I'll ask Fiona to offer some thoughts on the themes that Isaac outlines. And then I want to engage them on a set of questions that, sort of triggered in my mind as I read the volume, before we go to an interaction with the floor and with our virtual audience. So without further ado, Isaac, the floor is yours.
Well, thank you so much, Ashley. It's really a privilege to sit on the stage with you and Fiona, and I am overjoyed to be discussing this attractive volume from Yale University Press that is available for sale outside. I don't want to give a book talk, though. I really want to talk about the themes in the book, because I really want to engage my colleagues here in a discussion on a set of issues that I think really implicate quite a lot of important strategic equities from whatever perspective you're looking at it. And just to give you sort of the basic overview of what I'm trying to do in this book, it is, as advertised, a book about China and the law of the sea. It's about rules and order. I've been interested in China and the law of the sea ever since they published this now infamous 9-dash line map, trying to understand what this means. And what this book does is it's sort of a culminating effort in a long-term process of trying to understand what it is that China intends when they're saying, this is the rule for how we claim sovereign rights and jurisdiction. These are the terms of art under the law of the sea. Or maybe in a way that I tried to gesture at in the cover here, just how far out to sea does China's sovereignty extend? It's a crude way of thinking about it, but that's effectively what the law of the sea as a rule set, as a way of ordering the maritime domain, what it's intended to do. It's intended to balance the rights and the interests of various states, the coastal state, another term of art, and the user states or the flag states. And so the bottom line up front about this question of, well, what are China's rules? Is China making the rules? Who makes the rules? And what I come to, and I'm happy to get into this in detail on specific rules, but overall, I don't see much evidence that China is making the rules. What you see is China is making the rules less effective. And that's especially the case in East Asia, for reasons that maybe are obvious. That's the maritime space in which China is, in fact, claiming rights and jurisdiction and some type of sovereignty. But one important implication of that is that these are largely regional effects, and we're talking about the East Asian maritime order, I think, is ultimately the object on which China's law of the sea has really had the most effect. So as you can see from this table of contents, I'm looking at a couple different rule sets as the preferred jargon around these parts, and they're sort of clustering together a few different specific rules under the law of the sea, not just the treaty, but the broader customary body on which China and mostly its regional neighbors have disputes. There are some, largely the navigational disputes, which you see there towards the end of the volume, that implicate the United States. And in some of those cases, those rules implicate only the United States. And what I've tried to do is understand this interaction, because rules, however you think of them, and there are different ways to understand international law. That's only one type of rule, of course. But at a basic bare minimum, it requires a state trying to act or practice in a way that's consistent with its version of the rules, and some other states who are affected by it accepting that in some way, acquiescing to it at least. And so I tried to do that across the board, across all these disputed rule sets, because I think the character of the order is going to be reflected in some way in that. And I'll dive in on just one kind of cross-section of the book, which is very empirical, and it's very in detail on the law of the sea, and it'll be rewarding for people who want to go there, but I think the bookends, the introduction, the conclusion should be good for everyone to understand why this matters. But just thinking about resource issues, I think, is important for us, especially here in Washington, because there's been a very significant emphasis on navigational rights. The now infamous FONOP program has become synonymous with U.S. military presence in East Asia, or U.S. commitment to allies in East Asia. And I think that's unfortunate for a lot of reasons, which we can talk about. But most importantly, China's primary maritime disputes are with its regional neighbors. They concern things like their boundaries. They concern things like their rights to resources and a variety of other things implicated at their authority to regulate its commercial activities and to conserve the environment, et cetera. What we're looking at here on the left is a map from the book. It is not a map that has been authorized by any sovereign state nor submitted, but it is a notional projection of what we see China actually articulating in its practice. And this is a combination of what they have put into their domestic law, what they've submitted to the UN, and what they've done with their practical maritime apparatus, their Coast Guard especially, but also a whole range of other maritime law enforcement and as well as commercial actors for reasons that we can talk about. But that version of the law of the sea, what I'm calling China's law of the sea, their particular version of rules, is now in something of a direct contradiction with at least one mainstream view on international law that's been articulated in this South China Sea arbitration, which was ongoing during the period I was doing most of my field work, which was largely in Hainan, the little South China Sea island not far from Vietnam. That's the southernmost undisputed portion of Chinese territory. But as many of you will probably know, there are many points further south, as far south as 4 degrees north latitude at a submerged reef 20 meters under the seabed where China is claiming some type of rights. That's coming up in very, very difficult, kind of contradictory collision with this idea enshrined now in a treaty, the United Nations Convention on the Law of the Sea, UNCLOS, that states like the Philippines, which is pictured here on the right, with some of its oil blocks and the projection of its 200 nautical mile EEZ from its coastline, just a basic bare minimum that they would be entitled to just from an undisputed portion of their main islands. There's an irreconcilable conflict here, and in practice what has emerged is the law of the sea is not being enforced or implemented in not just the South China Sea. It bears noting this map is the whole East Asian littoral. I'm talking about all the areas in which China claims jurisdiction. In effect, they have exercised what I call a veto jurisdiction over other states exploiting resources within their exclusive economic zones, their continental shelves, even their territorial seas in some cases. So I want us to focus on these practical effects. And again, there in the resource case, I think what we mostly see is not rule-making behavior, but rather it's a rule-diluting behavior at a minimum. And it's certainly not the case that states that claim sovereign rights to the fish or to the oil and gas or to any mineral resources of the seabed are acquiescing or accepting that China has some legitimate right to it, but they're unable to exploit it themselves. And I think that's a really key practical feature of the order, the maritime order that we see in East Asia. The last thing I'll say, and it has to do with, it's another South China Sea map, but it's obviously this U-shaped line map and the big arbitration that the Philippines brought to the Chinese under the United Nations Convention on the Law of the Sea in 2013. These have major effects on what the rules might well be. These are two extreme ways of projecting on this map what would happen if we were to apply an extreme version of China's Law of the Sea, which is to say that leftmost map that geographers at the State Department put together, where you say, all these islands, all these disputed islands, rocks, reefs, atolls, in fact can generate the full panoply of maritime zones. These are, of course, notional, and there's no way that these would be negotiated boundaries. But just starting from that premise, that's sort of where China is on purely the law of the sea. That's the legal argument. We'll negotiate from there. But they also employ a variety of historical claims and what I would argue a variety of practical claims. This idea of effective control, 有效控制, something I heard a lot of in conversations with China's maritime law enforcement community in particular. That's how they understood their mission, to embody China's sovereignty in the form of the state practicing its jurisdiction and its authority. So I just want to leave on that note and suggest that the far right version, where I've perhaps not artfully sketched out this high seas comma, you might call it, that's if you do the inverse thing. You say none of these islands matter. That's effectively what the South China Sea arbitration is saying. That little map in the inset is showing the effects of that. They're just little pockets of maybe 12 nautical miles around some of the features. And what you would have there is an entirely different sort of maritime order, and one that perhaps would be more conducive to the rules of the law of the sea being applied. But that would entail a big area of non-jurisdictional space, right in the middle of the South China Sea. That would be high seas territory. There is, in fact, a high seas treaty that just opened up for ratification. So these are rules that are in flux. I think that's the last thing that I want to leave us with and maybe have a conversation about it, is that these rules, even though they have been evolving for centuries in the form of this customary international law of the sea, there are new legal instruments, there are new technologies, there are new rising powers on the world stage, and we're watching this play out in real time, and I'm very eager to hear from my colleagues on what they make of it all.
Well, thank you, Isaac. I'm going to come back to some of these issues, almost stepping back from the detail in the book, and I'll talk about some of the detail in the book in my interventions. But Fiona, the floor is yours.
Okay, super. Well, thank you all for coming, but most of all, thank you to Ashley and especially to Isaac for writing, I think, what's a really magnificent book that gives us the occasion to get together and to talk about all of these issues. I'm going to pull out some of the kind of big picture takeaways that speak to what we can extrapolate from Isaac's research about, broadly speaking, China's effect on international rules, how it may plan to do so. But before that, I just want to emphasize that not many people would be able to combine a sort of deep subject matter expertise in China's maritime behavior and intentions, informed by extensive field work, with a kind of mastery of international law and the political science literature on international order. This is quite an extraordinary kind of combination of expertise that's coming together in this piece of work. And I think the sum of all of those pieces is greater than the parts. I really want to commend Isaac for that. And I should also just confess, I went to law school as an undergraduate before I became a political scientist. So I admire anybody who is able to combine those more effectively in their work than I have ever managed to. So what stood out to me in the book, I think I'll talk about sort of three things. I think perhaps the most important kind of implication of Isaac's research is that what it tells us about the relationship between China's regional ambitions and its ability to reshape the rules and its global ambitions and ability to reshape the order or orders that govern and kind of create meaning in international life. And so I'm going to quote a little bit from his concluding paragraph, because I think this is a really insightful and useful way to sort of look at this question. So he writes that the new rules that Beijing seeks to apply are idiosyncratic, particular to its disadvantaged geography, fueled by specific nationalist grievances or national grievances, and shaped by China's unique geopolitical position in an uncertain American hegemony. And so he writes that China's law of the sea is not viable for export, but UNCLOS rules that China contests are rather sort of not applying in the region, leading to a less rule-governed maritime East Asia. And I think this is so remarkable because as you read through the book, you notice what an extraordinary kind of concerted effort that the Chinese party state has put into trying to promote China's preferred interpretation of the rules of the sea. And so I think this conclusion raises some really important kind of questions for us sitting here in the United States, but in fact all countries that are grappling with China's rise about what China wants in international politics, this sort of perennial question. I think it questions this assumption that many of us here in Washington may bring about the global scope of China's ambitions and its ability to implement them. And here I saw an interesting connection with an op-ed in the New York Times written by Jessica Chen Weiss that appeared last week, sort of questioning whether China really had the capacity to achieve some of these global changes that generate concern. The second thing I think it does is to draw our attention to whether or not we can extrapolate so much from China's regional behavior in East Asia to try to expect or understand its behavior outside of its own region. It suggests that there may be some differences there. And I think one of the other things that really highlights to me is the importance of other states in assenting to the kinds of rules that China wants to see implemented within its region. To me, this was something that's really striking throughout the book, is that China can't change the rules unless other countries are also agreeing to it. And in some instances, they are unable, or they may even agree with the way that China decides to sort of frame the rules. But in other ways, they may choose to contest it. And so I think this creates an important sort of pointer for us to look at the way that other states react to the kinds of proposals that China might have about how it wants to see the rules change. But on the flip side, I think it also raises the issue of how states that do live in the Indo-Pacific in a regional order that may be sort of shaped by this different interpretation of the way in which the rules of the law of the sea should operate within China. How can they still have a say in the kinds of rules that they want to live under and the region that they want to live in, given the extent of contestation over some of those rules? And I think Isaac's points about the resource rules in particular really highlights this. I think it also points to some interesting kind of intersections between the way that China might seek to shape the rules in other kind of domains of international life, in other orders that may not be quite so geographically bounded. So in particular here, I have in mind cyberspace, some of the ways in which the book describes the kind of domestic consolidation of different organs of the party state to try and get to a more sort of concerted effort to promote China's rule of rules related to the law of the sea, really reminded me of the way in which China had done similar things with the various aspects of the party state that are interested in cyberspace around the same period of time in the early 2010s. But China's efforts to promote ideas like cyber sovereignty, which have some, I think, interesting parallels to some of these issues, do have a much, broader global scope. They're not geographically contained into this East Asian order. And so I think there are some interesting comparisons about how different sort of orders may operate in geographical versus more global sort of places. Okay, I'll just say two other things quickly on big themes that I thought were really worthwhile thinking about and talking about. The second big one was to think about how China's rise is going to affect the development of international law as being one of the important but not the only components of how international rules are made. And so I think Isaac's discussion of how and why international law is viewed in China in a fairly instrumental sort of way, and he uses this term of the weapon of international law, this is a fascinating discussion, and I think because it goes beyond just emphasizing the way that the party states' embrace of a rule by law at home is not the only reason why China sees international law in a more instrumental sense than perhaps it's spoken about in some, at least common law schools around the world. But rather there's this really important element to it that speaks to this historical legacy of unequal treaties that China experienced at the hands of imperial European powers in the late Qing dynasty. And so I don't think any student who becomes a political scientist who previously was a law student is going to dispute that there's an intensely political sort of nature to international law and that privilege is powerful actors. But I think the politics of international law in China are going to be different because of this combination of the party state, rule by law piece, and that historical legacy of sort of seeing international law in this more instrumental sense. And so I wonder what kind of implications this brings for the overall approach China might take to other bodies of international law, whether it's the law of armed conflict, whether it is the very important set of rules surrounding non-proliferation and safeguards, and whether China's approach may be similarly instrumental in ways that could have quite different sorts of implications. One of these may be that there are opportunities, in fact, for the way that the US approaches some rules that it would like to see in international politics with China, whether there are opportunities for kind of collusion as opposed to collision. And so I'll just conclude by noting that I think this conversation, this book, highlights the importance of being able to do really deep empirical research on matters to do with Chinese foreign policy, even when they are as contentious and as and kind of political as those of the law of the sea. I think Isaac's findings surprise me. They surprise me in ways that my own research looking at Chinese foreign policy also surprised me when I didn't find what I expected when I went looking for the answers. And so I think regardless of where you sit on the spectrum of seeking more competition with China or more cooperation with China, whether you're in a large power like the United States or a smaller power, I think there are real merits to understanding where China is coming from, why, the types of activities and behaviors it sees promoting its interests. And so I really hope that all of those of you who are students, who are researchers, who are in government, are inspired by this effort to be both creative as well as not be deterred by the challenges of doing this kind of work. So I'll pause there.
Thank you, Fiona. Well, I want to just start where Fiona sort of left us, which is I want to commend the book because it is a real example of what rigorous intellectual discipline can actually produce. It's an academic book, right? It's not a page turner. It's not something you're going to read.
He's right.
In half an hour.
Yourself.
But that doesn't mean you shouldn't buy it, because the payoff is that you will become smarter simply by working through the logic. And the logic is at times intestinal because the issues are not obvious issues to the casual reader. So you actually learn as you go through the book. But it's the methodology that Isaac uses to draw the inferences that he does, which I think transcend the subject matter of the book. And so for students, I mean, this is a great tutorial on how to do serious intellectual research which has profound policy consequences. Now, I'm going to step back and I want to lay out 3 baskets of big questions that I want to interrogate the two of you on. So when I was reading the book, there were 3 sets of questions that sort of jumped out at me. The first is, why is China doing this? Whatever the this is, right? We can talk about the this in a minute. But why is China doing this? I mean, there are not many countries. Maybe there are. And we'll come to that as well. Because I would make the argument that even though China's behavior in the maritime space may not be exportable precisely, China actually enjoys quite remarkable solidarities, especially in the global south, with respect to how it thinks about the management of maritime spaces. So in some sense, it may not have as difficult a challenge as we sometimes think it is. But the first set of questions that sort of leaps out at you is, why is China doing this? The second set of questions is, what is China actually doing? And you have to answer that, issue set by issue set, right? Because in the areas of resource claims, in the areas of navigation rules, in the areas of dispute resolution, China is doing different things. So there's no uniform yardstick that you can sort of pull out of there. And there's a derivative question to question number 2, which is not only what is China doing, but actually how is it doing it? And then, of course, there's a third big basket of questions, which is what is the impact of all that China is doing on the rest of the international community? So I want to start with the first one, which is, why is China doing this? And if I understand your argument, Isaac, you start by saying China is the legatee of a very painful historical past, and it wants to rectify those perceived wrongs, right? And now that it is a state with capabilities, it sees this as a moment of opportunity, more or less. Then, of course, layered up on top of that is that it is an authoritarian party state. And the party state brings its own sort of nuances to this ambitious vision of entitlements. And the parallels that you draw between Chinese domestic law and international law and stuff are fascinating from this point of view. And then there's the third variable, which is China's rising power. And that sort of provides it with the grist to be able to go out and get away with the things that it's doing. So a couple of questions there. Let's take the historic wrongs as a given. We can't change that. But if you had a different kind of domestic regime in China, would you see fundamental differences in how China approaches this business of having ambitious entitlements? In other words, I'm trying to understand what additionality, if I may use the word, does the domestic character of the Chinese state bring to the problem? Would states that might also have historic grievances, but have a different kind of regime, respond to these challenges in different ways? And then the second question, this is for both Fiona and Isaac, is that yes, of course, all this is meaningful today because China is rising, right? If China was just another inconsequential power, I don't think we'd be paying too much attention to whatever China's claims are. But how much of this also hinges on the character of the local balance of power around China itself? In other words, if China was rising but was buffeted by very powerful states, would China's behaviors with respect to its assertions change? So let's start with that, and then I want to push a couple of layers below in terms of your argument, which I think is fascinating. So over to you.
Well, thank you so much, Ashley. That is high praise and deeply insightful questions that I will have to wrestle with. I don't think I'll be able to do it full justice here, especially with wanting to hear how Fiona looks at this in other domains other than the law of the sea. But she and I were talking about some of the common threads that we might see as a result in part of the way that China is organized, or the way the party state is constituted, which I guess it's worth noting, it's not constituted in the way that we think of our government as constituted. They seized power in the midst of a civil war and built the plane while they were flying it. The legal system has been developed kind of as almost an afterthought. It's not a weight-bearing structure in Chinese governance. I'm looking at Professor Ken Lieberthal here, who has studied the Chinese party state with more depth than anybody may be able to in the near future, having actually had access to understanding how they govern. And I guess the thread that I wanted to point to here, and it relates to this historical sense of grievance, or the historiography of the century of humiliation that many of us, I'm sure, are familiar with, is this is mostly a story about sovereignty. Sovereignty is the theme. It is the core norm of the international legal system. China is a hyper-sovereigntist sort of state, and they're not alone in that. This is something we'll come back to. That's a characteristic of lots of the post-colonial world, or the developing world, or what Mao Zedong coined as the third world. This is a natural constituency for this attitude towards international law, which lends itself to being quite instrumental and even cynical, right? Because the early experiences with international law were precisely its use as a weapon against India, for example, as a method of colonization. In East Asia, other manifestations of it. And so international law starts at that stage. This is not to say that China considers it illegitimate, nor do the rest of these developing states, but it does speak to the why, and it speaks to what we might expect to see a different type of regime. I would posit, and we do even have this experiment, unfortunately, playing out in real time. There is another potential Chinese government that is not a Marxist-Leninist party state. I think it's just a Leninist or former Leninist state. So some commonalities there. And their attitudes on some of these issues are actually quite aligned. And I think, again, that hardcore commonality is they're both rooted in a very, very keen sense of sovereignty being the dominant norm, and international law is subordinate to it. That is the card for entry into international law to begin with, from China's very severe and arguably quite legalistic view of the matter. And I'm curious, maybe I'll pass the mic to Fiona, because this norm of cyber sovereignty has always jumped out at me as this is the obvious comparative case for me. They're saying it exactly out loud. It's the same story, but it's a different domain. It's the same party state. And I guess before I do that, I'll just say one last thing. There's a whole section where I'm trying to understand the legacy of, for example, a Leninist organization of the party state for how you use law. Fiona and I have been talking about this for a while. Lenin described it in terms of the party center should be like the conductor at the head of the orchestra, and he needs to be able to spot when the third violin plays a false note. And the law is the instrumental way to do that. It's an administrative tool. It's the best governance technology out there, but it's not constituting their state. To circle back to that, it is a tool to be used and to be discarded in certain instances, particularly when sovereignty is more important.
Okay, so I think these are, again, really terrific questions, and I'll try to add a little sheen on what Isaac has already noted. I think starting with, like, how does the regime type matter in how China has pursued this set of interests? I'll start just by reflecting on this cyber comparison. I think one of the differences here is that the nature of the rules of cyberspace matter more for China's regime security perhaps than the maritime order does, which is not to say that the maritime order is also not quite important for the regime in particular, in the way that the defense of kind of territory and sovereignty is part of the party state's message to its people, for the way that it remains in power. Isaac mentioned the piece about sovereignty and I've said a little bit about nationalism as being sort of one of the key reasons that's driving China's behavior in this area. But how would it go about this differently if it was a different type of regime? So one of the things I think that would be different is perhaps the relationship with international law might look a little bit different, right? That the rule by law piece, Isaac argues, is important as opposed to a rule by law kind of attitude to the role of law domestically. And I think that matters to the instrumental way in which China is using international law. So that piece sort of spills over. A second thing that I think would be different is the ability of a different type of regime to mobilize the state in the way that China has managed to. And so that again comes across very clearly in Isaac's chapter on sort of the structure of the kind of rules of the sea formulation, implementation within China, that there is a kind of mobilizational quality to it. And that is something that the PRC regime is really very good at doing. So that's a sort of second difference. The other thing that I want to point out that I think is, we haven't quite touched on this just yet, that I think is really interesting within this piece is the tension between being a rising power that has also staked a lot of its diplomacy and its own sort of, I guess, identity on a kind of developing state, global south, non-aligned. That kind of history is really important within China's foreign policy, and it's clashing in interesting ways with its status as a rising power. And so you see this in climate, you see it in cyberspace, and I think you see it very clearly in the kind of global versus regional differences in China's approach to the law of the sea. I'll take a stab at the balance of power question as well if we have the time. But I think three things really quickly. I think the geographical rules chapter of Isaac's book is quite interesting because it discusses the difference in the way that China kind of ends up having kind of contesting the geographical rules of the law of the sea with its Northeast Asian neighbors in South Korea and Japan versus in the South China Sea, and seeing sort of differences in some ways in the way that it's pressing its claims more assertively in the kind of South China Sea space. That might give you a test case of just how you go about, or how China thinks about its ability to press those claims when it's faced with more powerful states as opposed to less powerful states. The second thing is kind of the bilateral versus multilateral nature of how China might approach this issue if it were faced with more powerful states on its periphery. Generally speaking, I think operating in a multilateral environment helps China when it is strong, but when it is when it's faced with weaker actors, but it may prefer a more bilateral sort of way of contesting its claims when it is doing so against stronger actors. The final piece I'll just add is that the US is obviously still a pretty strong actor in China's periphery when it comes to discussing the kind of law of the sea within East Asia. But there is something about the maritime domain where presence is fluid. And so the fact that the United States can move from one place and not to the other, you can't be everywhere. Also, I think just the nature of that kind of the physical characteristics of the space means that even powerful states are going to have some challenges in being everywhere all at once.
Well, water has peculiar physical effects.
Absolutely.
Right? And so that's wonderful. I want to move to the second question, because I think what Isaac's book does is it exposes, in some ways, the sophistication of China's strategy for its entitlement claims. And this goes to the second basket of questions which I asked, what is China doing? Now, China is doing a lot of things. I'm not going to summarize that because it really varies from dispute set to dispute set. But what is uniform across all dispute sets is how it's doing it, right? And what I found fascinating in your book was China is not challenging the memorialized text of UNCLOS. It obviously had various positions in the discussions leading up to UNCLOS, many of which were not accepted and did not make the final cut. And for those of you who don't follow sort of the details on this, the broad debates were essentially between traditional maritime powers who basically emphasized freedom of navigation, which is we want to be able to use the oceans any way we please beyond the 12 nautical mile limit, which constitutes territorial seas. And all the other rising states or the global south states, which were not traditional maritime powers, who found the idea of the traditional maritime powers doing whatever they like in the oceans to be very threatening or prejudicial, at the very least, to their security, sovereignty, so on and so forth. And so what the emerging countries attempted to do was to foist on what was a traditional system of mare liberum, a regime which allowed them to exercise some sovereign functions over water and airspaces, right? So that was the essence of the contestation that led up to UNCLOS. Now, what I found interesting in your book was that the Chinese are not challenging the text per se, but they recognize that there are two drivers of change. One is the text, and the other is essentially state practice, because that shapes a second driver, which is customary international law. And customary international law is essentially what you make of it as a result of the accretion of custom, right? And so what the Chinese are trying to do is not frontally take on UNCLOS, but to act in ways that advance their interests in those areas where UNCLOS is either silent or ambiguous. And by acting in certain specific ways that advance Chinese interests, attempting to create a whole body of precedents that, if unchallenged, in time would become a new building block of customary international law. Am I reading this right?
I've heard in Chinese more or less that description of what China's practice is intended to do. That is my working theory of the case, because it's the working theory of the case shared by the international law and maritime policy community in China, and it's the one articulated by Xi Jinping in so many words. It's effectively this idea that, well, the rules as written down in black letters in this treaty are in fact disadvantageous to us. If you look back at the record of China's participation in the conference to develop the law of the sea, their discussion in the National People's Congress about whether and when and how to ratify, they plainly, in the minutes of these meetings, acknowledged that there are shortcomings and defects and effectively disadvantages that are baked into the cake, because China is actually a geographically disadvantaged state from the standpoint of a new regime that projects big maritime zones. You don't need to look further than, I put this whole Asian littoral map up here because I'm gonna make a point about these navigational rules. But it's zone locked in the terms of the law of the sea, but they're basically set up to have truncated entitlements at best and to be inferior to Japan, for example, right there. I've heard a lot about how does China sign this treaty that gives Japan the right to these vast exclusive economic zones, but gives China less than the normal entitlement just by virtue of its geography. But customary law, I think, is sort of the solution that percolated out of this international law community, is how do we reconcile the fact that China's policy, their choice about how to treat this space, is not going to, because of the sovereignty claims that have been kind of built up and accreted, not unlike the artificial islands that they're building there. This is an evolving set of interests and policies and frankly, capacity and capability. I wanted to link that to this balance of power question, which I missed, and suggest a way of thinking about it, which is China still assesses the East Asian littoral to be a space in which they face some major strategic disadvantages too. I do believe the encirclement or containment fear is genuine in some very significant way. The alliance with Japan, the alliance with Korea, the alliance with Australia, and many other allies and partners there are quite problematic and will remain that way. And that's one of the reasons that international law and the law of the sea suggests itself as a useful instrument for advancing Chinese interests. It's establishing Chinese effective control below the threshold of using military force to achieve it, which would be at a minimum, very costly, highly uncertain. This is a much more gradual, potentially peaceful process, but it is linked up with a couple of things that are quite potentially escalatory. And so I wanted to just draw us to one particular rule that I go into a lot of detail in the book. And it's one that maybe a lot of people here are familiar with because it's the typical thing that US funds are challenging, these freedom of navigation operations. They challenge a number of things, but one that's been quite consistent is this idea that military vessels enjoy a right of innocent passage. And what that means is you can go from point A outside the territorial sea to point B outside it on the other side and pass straight through without pointing your guns at anyone or flying aircraft off your ship or doing any number of things. And that is an unadulterated right in the text of the Law of the Sea Treaty that China, in fact, acknowledges. You're talking about they are quite keen to remain in something like good standing with the Law of the Sea. They will offer a legalistic argument for why what they're doing is consistent with the Law of the Sea. That's the nature of a lot of international law. Treaties are often basically disagreements reduced to writing. They've established a broad scope of possibilities that might be exploited, and China is exploiting them in these extreme ways that I've showed from a law standpoint. They don't expect those claims to be honored in the breach. Innocent passage is the only rule that I found up until these dispute resolution norms where China's practice was sufficiently uniform and consistent, and that other states, to include basically all of the states across the East Asian littoral, have some level of discomfort and some level of what the United States would call excessive claims, restrictions on navigation of some kind in their territorial seas, in their contiguous zones, in their exclusive economic zones. China wrote, when it ratified the treaty, it submitted an unauthorized signing statement. You're not allowed to reserve anything from this treaty, but what they said was quite clear. We must authorize innocent passage. They argued vociferously for exactly that language in the treaty itself. It's all in the record. They banged on the table about it, and it was not included for precisely the reasons that Ashley explained. There was basically a balance between there's a strong maritime powers that want more openness, and the weaker states in the developing world that don't. And the really interesting thing that's happened now, and this will be the last thing I say about it, is that China, by its own accord, is a strong maritime power now. It wasn't before. And whether or not this creates inconsistencies is the last thing that I wanted to take. I think this is the third last thing, but I'm realizing Fiona teed me up, which is that, on this question of whether it's exportable, it's that China has not invested in creating universal rules of any kind, the way that international law purports to do. They're finding their space within a system that is defined by that, and they want to renovate it from the inside out, as it were. Yeah. A UN-centric system is what you hear Chinese diplomats talk about, and that's a venue, a framework in which they enjoy not just their sovereignty, but their hyper-sovereignty. They're on the Security Council. Nothing's going to happen there legally without them giving it a chop. Yeah. So, curious your take on that, Fiona.
Don't answer that question. Yeah. There is a further question I want to ask before I go to the floor, and that's the issue of impact. So Fiona, the question is, if Isaac is right, that the avenue that the Chinese are using is essentially shaping of customary international law through practice. And if we have to look for ways to avoid creating new precedents in the system that become new norms and eventually become new law, does that mean that we are fated to essentially oppose these Chinese practices wherever they may materialize, wherever there are ambiguities or wherever there are silences in the memorialized text?
That's a tough one to finish with. So, I mean, I think I'll just pull out some nuances from the book, which I think will help us to sort of unpack this question. One is that not all of China's practices are consistent, right, in contesting all of these rules. And so I think other countries who want to contest these rules from becoming custom can also exploit the fact that China itself isn't entirely consistent sometimes in how it pursues these rules. So you have a sort of focus directed on those where China is really consistent with its practice as well as its statements. And the innocent passage piece, I think, is one Isaac drew out that is particularly sort of pertinent in this way. So I would say you can sort of focus on the ones that are going to matter the most by looking at just how consistent Chinese practice is in those areas as well as its statements. I think the second piece is you have to focus also on which rules are just China and which rules actually have broader support in the international community, because ultimately we won't get into the sort of discussion of different types of orders, but other states have a say in the rules that may not be the types of rules that those Mare Liberum kind of, I said it wrong probably, but the open sort of seas states are really interested in. And so you have to put China's contesting of these rules in the broader context that it's not the only one that may have certain sorts of attitudes. So being sensitive to those places where what China is doing is genuinely something that may have a significant amount of opposition, including among states that have difficulty contesting China because it's a big and powerful actor economically, militarily, politically, from those where maybe the international rules do need to have a little bit of slip and a little bit of give to be able to accommodate the interests of a broader range of countries. So that's the sort of second piece. The third, I think, is when you work where you are contesting those rules, it will often come down to sort of capacity, right? So when Isaac discusses the kind of resource rules and talks about this veto jurisdiction that China has sort of developed where, it doesn't set the rules, but it has the ability to sort of block some of its regional neighbours from pursuing their resource claims when they want to. Well, the way in which you would go about contesting that is to provide them with greater capacity so that if they do want to contest them, they're able to do so, but if they choose not to, then they're not. The last thing I'll just say that I think is really an important sort of overall takeaway from this piece is that you have a sort of trade-off, right, between restraining yourself when it comes to a set of rules or a body of rules that you want to see preserved and pursuing your own self-interest. The United States has had a particular relationship to that trade-off of sort of self-restraint for the purposes of having some broader rules that will constrain others. And I get the sense that China is still sort of working out where its trade-off is going to be between setting rules that, broadly speaking, will further China's interests, that will restrain countries from doing things that China doesn't like, but that on occasion is also going to restrain China from doing things that it wants to do. And there is a risk, I think, if you push the kind of challenges to some of these orders too far, then you end up undermining the whole set of rules so that you can't kind of have your cake and eat it too. That's the challenge, I think, that powerful actors face. And I'm really curious to see where China goes in thinking through that trade-off going forward.
Absolutely, and we face this dilemma with everything from the maritime space to the way we use sanctions, dollar supremacy, and so on and so forth. I am conscious of the time, and I'm constantly being warned that this will come to an end, even though I'd like to carry on this conversation. But there is one question from virtually, which I'll lay on the table, and then I'll go to you, sir, so you can ask your question. What do you make of China's non-recognition of the UNCLOS-based compulsory dispute resolution, such as the Philippines versus China ruling? Is this ad hoc, or is non-recognition a norm by itself? So just hold that thought. And yes, sir, if you can.
Mark Kennedy Wilson Center, 2 questions. Does America
Oh, there's a microphone, please. Yep, thank you.
Mark Kennedy Wilson Center, does America not endorsing the law of the sea impact our ability to enforce it? And the second is, are we seeing a prelude to space? Because right now we're looking to explore and put settlements in space, and what's going on here in the sea might be what we might be seeing going on in space. Thank you.
Anyone else? I'm going to take 2 more and then we can close. Yes, sir.
Yes. I'm Peter Humphrey, an intelligence analyst and a former diplomat. The key to China's UN-run system is non-interference in our internal affairs. That means we can castrate Uyghurs and Tibetans and Kazakhs as much as we want, And if the Burmese want to do the same thing to Rohingya, they can do so as much as they want. And if we want to complain against dalliance in our South China Sea, well, that's our internal affair. So I think that's the key principle to the direction China's moving in. My question is, I'm fully expecting China to, as a sort of, to lay out robotic weapon systems peppered throughout the South China Sea. We call them encapsulated torpedoes. They are AI-driven systems that hear a certain ship and then can activate. Do we have any legal recourse whatsoever to fighting automated weapon systems throughout the waters that China is claiming?
So, young lady here, and then Ken Lieberthal, and then I'm sorry, but we'll have to close the conversation because I'm reminded of the deadlines. Go ahead, ma'am.
Yeah, I was curious about the rule diluting behavior in respect to the Arctic Council, especially with, can we foresee any further disputes or conflict that would arise in respect to climate change and high sea level rise and the melting of the poles? So I was curious to know how that played.
Okay. Ken? Done? Okay, all right. Okay, one last one there, please.
Yes, thank you for your talk. Confucius spoke of the importance to rectify the names. And this is an exact quote. He said, 名不正则言不顺,言不顺则事不成, which basically means if you don't use the correct names, then your words are not clear. And if your words are not clear, then your actions will not be correct. So the body of water that we're discussing in English, we call the South China Sea. In the Philippines, I believe, they now officially refer to as the West Philippine Sea. In Vietnam, they call it the East Sea. So, and as this map shows, if internationally law were correctly interpreted, everybody gets a fair slice. So then there's an international zone in the middle. So I'm wondering if we should start considering in English coming up with a new name. Thank you.
All right. Over to the two of you. I mean, if you want to share the questions, that's perfectly fine.
You want to take the ones that appeal to you, and then I'll try and back clean up.
I mean, I think many of them were sort of more specific aspects that I think, Isaac, based on your extensive knowledge of this area, you may be better placed to answer than I am. I think what I will just take one stab at is the question on space, because I thought a little bit as I was reading this book of, what are the parallels and what are the differences between other areas alongside the seas that, we think about in the same sort of breath, space and cyberspace being perhaps the two sort of closest analogs. And outer space has a slightly more sort of physical characteristic, if you like, than cyberspace, but at the same time, has a sort of different quality from the geographical sort of constraints within the region. The big difference there, I would say, is that you don't have a constitution for space and you don't have a constitution for cyberspace. There is not an UNCLOS type of regime that has, there's obviously, you have your Outer Space Treaty, which has a degree of adherence to it, and the Moon Treaty with less sort of, widespread adherence to it. But that same sort of constitutional foundation in terms of international law, to my mind, doesn't quite exist to the same degree in space. And so I think in those areas, you are going to see different, perhaps, tools that are going to be employed or different segments of international law that are going to be sort of leveraged to pursue Chinese or other countries' interests in that space. So I'd expect the toolkit to look a little bit different with a bit of law, but perhaps a bit less than in the seas. And I'll hand it over.
Thank you, Fiona. And mindful that we're short on time, I won't do justice to a bunch of these interesting questions, but I do think I can bundle them together to make a couple points that are still left out there. The non-recognition of the compulsory dispute resolution mechanisms in UNCLOS, it's a mouthful, is something that China also wrote in a subtle way into its signing statement, which is to say they prefer bilateral consultation and dialogue as a way to solve anything that bears in any way on sovereignty, which is to say it's within their sovereign discretion to determine whether it bears on sovereignty, and they're going to exclude themselves, exempt themselves. We may be familiar with this sort of behavior because, this leads to my second point, the US should accede to the law of the sea. It should also take up for ratification this new High Seas Treaty because we're outside of this process of making the rules now. Our lawyers make a legalistic argument that's sound enough on the merits that the customary international law is in fact binding on the United States. And we do in fact follow the rules in a lot of ways that are inconceivable for most states that don't have a JAG or a lawyer in every room when you're discussing what you're going to do with your Navy. We are quite interested in it, and yet for reasons that are above my pay grade, we cannot mobilize to do that. China is effectively running away with our rules-based international order by sitting in these bodies, staffing them, funding them. My colleague Courtney Fung has written very persuasively about the various mechanisms of this. And the United States kind of shrugs at it because we say, oh, these international legal regimes and treaties are not for us. We prize our sovereignty too, and they're dragging things, global governance in ways we don't want to see. But by not acceding to them, by not being willing to bear what I would argue are quite modest costs for the United States to play, to ante up, and to be participating in making the rules in this formal sense, as well as in the practical sense, in our state practice, which we also should continue to prioritize, I think it's a real priority. I guess I definitely will not have anything to say about the existence of robots anywhere in the South China Sea, other than to say there are operational implications to China's law enforcement actions and to its presence. The Navy tends to be over the horizon, as they say. You don't see a lot of PLA Navy involved in most of the practice that I'm talking about. They're just underwriting it with some capability that hasn't really been deployed, frankly, or certainly not employed in a kinetic fight. What we see is using these military and Coast Guard and fishing bases across the South China Sea, as well as China's increasing Coast Guard patrols, for example, in the territorial seas around the Senkaku or Diaoyu Islands. What we see is them preparing the battlefield, as it were, creating new norms about who operates where, who observes what you do on a regular basis, and basically eroding the application of law of the sea rules one practical act at a time. And I think we're still watching that, and it's not too late to change aspects of it. I think this South China Sea arbitration, the last thing I'll say, the United States could not be sued under the law of the sea because we haven't ratified the treaty. And when we tell China, you should follow that award, but we won't subject ourselves to that same discipline, it's not just rhetorically inconvenient. It actually is not a persuasive argument. It does not win over the region, and it does not cost us very much. This is a quick and dirty way to compete more effectively with China, to be in this treaty framework, and we will work out those details as they bear on U.S. interests in the course of time. If we're serious about not having China effectively control the East Asian littoral, this should be something that's higher up on the priority list.
Well, I apologize to those who I couldn't get to, both here and virtually. But as you might tell, we've just dipped our toes into a subject that has a long life ahead of it and is not going to disappear anytime soon. Thank you all for coming. On your behalf, I want to thank Isaac and Fiona for giving us the opportunity to have this conversation. And I promise you that this will not be the last conversation we have on the subject. So I look forward to seeing you back here at Carnegie, either in person or through the airwaves at some future point to discuss this and many other issues that are the subject of our research. So thank you all very much and have a wonderful evening. Take care.
Thank you, Oscar.
That was great.
Appreciate it.
Pleasure.
Thanks, Fiona. Good. It only
Great.
cost you 6 credit cards to come and
I know. Small price to pay for